You've seen it 1,000 times in movies and TV shows. We got a confession. Case closed, right? Well, maybe not. What if I told you that in a real courtroom, a confession can be completely thrown out, even if the suspect meant every single word? Because it turns out the law is often less about what was said and a whole lot more about how it was said. All right, so here's our game plan. We're going to break down why a confession isn't always the end of the story. We'll get into a judge's special powers, unpack what unfairness really means in court, look at some historic rules that started it all, dive into some, let's call them questionable interrogation tactics, and finally, see how this all comes down to a constant balancing act. Let's get into it. Okay, so first things first, we have to start with this fundamental tension that's right at the heart of criminal justice. I mean, you have to ask, right? If someone just comes out and admits to a crime, shouldn't that be game over? Well, the legal system's answer to that is a surprising and very firm, not necessarily. And here's why. It's this constant balancing act. On one side, police have to be able to question people. I mean, without that, so many crimes would just go unsolved. But on the other side, the person being questioned has to be protected from unfair or improper pressure, especially when they're in a vulnerable situation. That's the core conflict. So, how does the court actually handle this conflict? Well, this is where a judge steps in, and they come equipped with a special set of tools called discretionary powers. This brings us to a really powerful concept, discretionary rejection. What this means is that a judge can look at a confession that seems perfectly fine on the surface, totally voluntary, and still say, nope, we're not using this. And the reason is simple. The goal isn't just getting any conviction, it's about getting a fair one. So a judge can toss out a confession for one of three main reasons. First, simple unfairness to the accused in how it was obtained. Second, if it was obtained illegally, meaning the police just plain broke the law to get it. And third, and this one's a little more subtle, is if the confession's prejudicial effect would completely outweigh its actual value as evidence. Basically, it might just poison the jury's mind. Now, of those three reasons, that first one, unfairness, is often the most complicated and the most nuanced. So let's zoom in on that. But that immediately brings up a huge question. Unfair sounds pretty straightforward, but in a courtroom, it's anything but. There's no single definition you can look up in a book. It all comes down to the very specific circumstances of each case. And this idea was captured perfectly by Justice Fitzgerald, who said that fairness is an indefinable concept. You can't just pin it down with a simple rule. It depends on everything that happened in that specific situation. It's not a checklist, it's a judgment call. So what does all the circumstances actually cover? Well, the judge is basically trying to build a complete picture. They're looking at the accused person's age, their background, their intellect and education, even their literacy level. They're also looking at how the police behaved. Was it all by the book? And finally, they're asking, does this confession even sound reliable? All of those details get weighed together. To really understand where these modern ideas of fairness come from, we have to take a quick step back in time to a set of guidelines that pretty much changed everything. See, back in the 19th century, as modern police forces were taking shape, there weren't many rules about how they could question people. But over time, the court started to step in, recognizing that there's a huge power imbalance in that room. This all eventually led to the judge's rules in 1912. Now, these weren't technically laws, but they became a super powerful guide for proper police conduct. And those rules gave us one of the most famous phrases in all of law, the caution. The simple, powerful idea that suspects have to be told they are not obliged to say anything. This was a monumental shift. It was a check on the power of the state that put a little bit of crucial power back into the hands of the individual. Okay, so how do these historical principles actually play out in a modern interrogation room? Let's take a look at some specific police tactics. And you can really see the nuance here. For example, simply eavesdropping on a suspect, generally that's not considered unfair. But what happens when the police start using tricks or setting traps to get a confession? Well, that's when a judge is much more likely to step in and exclude it. The same thing goes for really oppressive, intense questioning or interviewing someone who's clearly in bad health. The line is often between observation and manipulation. Now here's a classic situation, one that gives courts a real headache. The police write up a detailed record of an interview, a confession basically, but the suspect refuses to sign it. So can it still be used against them? Well, the danger here isn't just about whether the notes are accurate. It's about the powerful psychological effect that a written document can have on a jury. As Justice Gibbs famously pointed out, the real risk is that a jury will give that unsigned paper an influence that's way out of proportion to what it's actually worth. I mean, just think about it. You're on a jury, and you get handed this official-looking police document. It feels heavy, it feels permanent. It can easily seem more credible than someone's memory or something they say out loud in court. And that physical presence can give it an influence that might unfairly tip the scales of justice. So this all brings us right back to that delicate balance we started with. It's not just about getting to the truth. It's about whether the path we take to get there upholds the integrity of the justice system itself. And here's the central takeaway from all of this. Even if a confession is 100% true, a court might still reject it. Why? Because if it was obtained unfairly, using it could actually do more damage to the public's faith in the justice system than whatever happens in that one case. In the end, the process really is just as important as the outcome. Which leaves us with a final and pretty profound question. Our entire system is built on the pursuit of truth, but it's also built on the principle of justice. And as we've seen, those two things don't always line up perfectly. Navigating that gap is one of the greatest challenges any legal system faces.